Hi, and welcome to Newswire LA. I'm your host, Chin Thomasangsi. We're back at the Ron Deaton Civic Auditorium in downtown Los Angeles, where we're continuing our coverage of the Showdown in downtown, better known as the debate for district attorney involving Alan Jackson and Jackie Lacey. Last week we showed you the candidates' opening statements and listened to their views about prison realignment. This week we'll continue with the abolition of the death penalty, retooling the three strikes law, and the Brady list. All of that and more on Newswire LA. We'll be right back after this. Welcome back, and we're going to pick up with the debate. Last week's session was relatively straightforward and to the point. There were a few moments of passionate discussion between the candidates, Alan Jackson and Jackie Lacey. As I mentioned, this week we'll be looking at the abolition of the death penalty, retooling three strikes, and the Brady list. The discussions you'll see and hear on these subjects will bring out new sides to these candidates. I'll remain with you as your guide and commentator for this debate, but it's you, the viewer, who will have to make that choice at the ballot box on November 6th. With that said, let's head back to this debate, which is graciously hosted by the Los Angeles County Organization of Police and Sheriffs. Let's rejoin Alan Jackson, Jackie Lacey, and moderator Warren Alney. We'll see you back here shortly. Question number 3. How do both these candidates stand on the question of repealing the California death penalty?
I do not support Proposition 34. I've gone on record as probably being the strongest candidate on this issue. I have said that I believe that the death penalty is an appropriate punishment for some of the worst criminals that we see. I've been on the death penalty committee for the last decade, except for when I was chief deputy for the last decade. I served, actually helped review every single case that our office decided to seek the death penalty on. And I believe that there are some cases where it's the appropriate punishment. Proposition 34, in my opinion, addresses the problem wrong. The appeal system does take too long. It is costly. But the solution is not to do away with a penalty that is appropriate for some of the worst, including people who murder police officers. Right now we have 42 or 43 people on death row who have murdered police officers. I would be especially likely to ask the death penalty for the case of a murdered officer, for the case of anybody who was murdered as part of the justice system, a witness killing, certainly people who murder children, people who go in and do mass murders like we're starting to see it in certain situations in movie theaters, and those are things where I think that when it's callous, when there are multiple deaths, those things I believe you have to have the death penalty reserved.
And now, it's Alan Jackson's turn.
I don't believe that it's well thought out. I don't believe that it's well conceived. The death penalty does serve an important purpose in the justice system. It absolutely does. There are certain crimes, there are certain criminals combined with those crimes that are so heinous, that cut so deeply at the fabric of our society, the fabric of our community. It requires us, I believe, as long as the death penalty is the law, it requires us to present that to a jury, to the community members, to the voice of the community, to speak out and determine, in their opinion, does this person deserve the ultimate punishment?
Both candidates agree that they do not support this proposition and agree there are times and crimes that are so egregious that the death penalty is the only remedy. Both also agree that the appeals process is so lengthy and complex that anyone arriving on death row may spend 2, 3, or more decades before the sentence is carried out, if it's ever carried out.
I'm one of the people who recognize, I support the death penalty, but I recognize the ills of the appellate process. There are broken parts of our appellate system. We have to start there. The mandatory appeals going straight to the Supreme Court, perhaps, and this has been suggested by a former Supreme Court Justice, California Supreme Court Justice, perhaps that is too burdensome for the Supreme Court. The Supreme Court is absolutely overwhelmed with mandatory appeals on capital cases. Perhaps they should be, the mandatory appeals should go up to the appellate level as the Justice had suggested. That would be one way to kind of speed the system along and to save the burden of a little bit of this expense. But the murder of a police officer represents something that the murder of a civilian doesn't. It represents an ability and a willingness on the killer's part. The intentional murder of a cop establishes the willingness of someone to basically say, the law does not and will never apply to me. I don't care about the law. I don't care what the badge represents. I don't care what the officer represents in our society. I'm willing to take the absolute ultimate step of intentionally taking the life of someone in law enforcement and ultimately in the justice system. I think it does deserve the highest scrutiny.
Okay. Though they share a similar philosophy on this subject, Ms. Lacey points out that there is a difference of degree that separates the pair.
Warren, can I have 45 seconds to respond? As part of the rules, we were told that if there was something, you start off with asking, do you support the initiative? And I answered the question, I do not support that initiative. When my opponent was answering this question with the LA Times, and the video was on the internet, he was not as strong about the death penalty. His position was he didn't want to politicize it. It's whatever the voters decide, didn't want to take necessarily a strong position. I think the district attorney of LA County must have done some soul searching, must have had experience with those cases, and must be strong on this very important issue. And I contend that is one difference between my opponent and I. I am willing to say unequivocally it's the right punishment for certain cases and willing to take a very strong stance about that.
It doesn't get any stronger. And by the way, Ms. Lacey may not understand what my stance actually is because she wasn't listening closely enough. What I have said is vote no on Prop 34. I don't know how to say it any more clearly. I am not in support of a ban on the death penalty. And as a matter of fact, it's not theoretical for me. In the last 12 months, I've put the last person that I tried on death row. This is not something that I'm soft on. It's not something that I'm equivocal on. In the last 12 months, I have stood on a swatch of carpet and asked for the death penalty from 12 members of the community, and they have fixed the penalty at death.
Question number 4, 3 strikes reform.
Prop 36, I'm not in agreement with. And I couldn't be more clear about this either, and I think this is a point of departure between Ms. Lacey and myself, and I'm sure she'll speak to this issue. Prop 36 is a weakening of the current three strikes sentencing scheme. It would basically mandate that certain crimes cannot be, even in the discretion of the district attorney, cannot be tried for a third or cannot be sentenced to a 25 to life sentence. It takes away the DA's discretion, ultimately, at the end of the day. And that's what I think the public pays us for, is to use our experience, which I've had in the courtroom and out, and to use our discretion. By the way, I should say up front, I am supportive, and I will continue the current 3 strikes policy that this administration has had since 2000. I'm not going to change that in the least, but this policy does include an element of discretion. The problem with the drafting of this current legislation is, and the police officers in the room should understand this, certain felonies would be utterly removed from the 3 strikes formula as we know it today. Attempted murder, aggravated assault, assault on a police officer, unless the perpetrator uses a machine gun. Those would all be excluded from our current 3 strikes formula, such that we could ask for a 3rd strike, even if the current felony is non-serious or non-violent. I think those drafting errors do violence to the spirit of the law. I will not support it. Ms. Lacey?
Miss Lacey, on the other hand, supports the changes proposed in the reform.
I do support the current initiative because I think it mirrors very closely our policy. You know, Mr. Jackson has said that he would follow our current policy. We already are doing what the initiative says in LA County. We've made it work for the last 10, 11 years. And so what we're saying is, and you know that there are constantly challenges to the three-strike policy. This is a way to take our way of doing it and make it statewide and protect it from any further erosion by some radical modification. So it's very important that we do this. I think this also will help with realignment. There are several people that are in state prison for life who were put there before this administration, who would have an opportunity to petition to be released, and that would leave more room for the more violent and serious criminals who should stay in. And so I'm supportive of it. It's already what we're doing. It seems to me it's a lack of leadership to say one thing, well, I support what we're doing here in LA County, and not want to extend it statewide. Our office, Warren, has been active in drafting that legislation. There are many that have gone on record as supporting it, and I support it as a common sense way for us to make this policy work throughout LA, throughout the state of California. And so I do support it, and it is a big difference between Mr. Jackson.
Ms. Lacey is absolutely wrong. She's just dead wrong. It is not the current policy. The state law, the initiative, the ballot initiative, is not the policy that we currently have in the district attorney's office. We can use our discretion. It's been a long time since Ms. Lacey's been in the courtroom. Maybe she's forgotten that certain circumstances require that we will, in fact, use our discretion. Head deputies throughout this county, head deputy DAs, are asked on a consistent basis, can we seek a third strike sentence even though the policy is, the presumptive policy is, that we won't? Can we deviate in this particular circumstance? In fact, if I had someone, and if the office had someone that was previously convicted of attempted murder, assault on a police officer, maybe another attempt of some kind of violent attempt, and that person is now caught walking down the street with a deadly weapon. The deadly weapon is an N3 felony. The deadly weapon is a non-serious, non-violent felony. But that might be a circumstance we would seek a 25-year life sentence. And under this new proposition, we would be foreclosed from doing so. That's why I don't agree with the proposition.
Okay.
Mr. Jackson's statement that Miss Lacey may not understand, or she hasn't been in the courtroom in a while, has been thrown out over the course of this evening. Miss Lacey, breaking her calm and thoughtful demeanor, strikes back.
And I resent the demeaning attitude of Mr. Jackson. You know that death penalty case that you tried? I was probably on the committee that approved it. I was probably on the person you had to come and seek approval from on that committee. And so to say that I am not familiar, I am out of touch, this is ridiculous. This lacks an understanding of what it means to actually run that office. We don't let lawyers independently in the courtroom just decide what they're going to do when there are 1,000 of them. There have to be policies and consistencies in place, and there has to be some accountability. And it seems to me that if you're going to be ready to lead an office of 1,000 prosecutors who will do whatever the heck they want to do without some leadership, you need to know some factual things about what's going on throughout the county. And that is a big difference between our understanding of how this office works. I understand how the office works. I have not been in an elite unit taking a couple of years to try a case and claiming you know exactly what's going on in the line level. I've spent most of my career on the front lines doing some of the cases that you're talking about. The chances are that I have probably prosecuted more third strike cases than Mr. Jackson had. That's probably the truth.
The question of the Brady bill is the next issue the candidates turn to. This particular issue is very specific to the law enforcement community. Basically, the Brady list came out of a landmark Supreme Court case, Brady versus Maryland, in which the prosecution withheld certain evidence regarding a law enforcement officer from defense counsel. Without taking you into the machinations of the entire ruling, the court ruled that prosecutors are required to notify defendants and their attorneys whenever a law enforcement official involved in their case has sustained a record for knowingly lying in an official capacity. The real discussion lies in the segue moderator Warren Alney takes, which simply asks if these two candidates would sacrifice winning a case in order to turn over previously unknown evidence to a defendant's counsel. The answer is obvious to anyone who's watched an episode of Law & Order, but the discussion between Alan Jackson and Jackie Lacey is the real thing.
Without question, and I have done that, and not on some dope case, on murder cases. Absolutely. My philosophy of what the district attorney's office is here to do is that we have never, none of the deputies, I didn't, no other deputy has ever raised their hand and sworn an oath to win a case. We raise our hand and swear an oath to seek justice. And justice can be sought, and justice can be gained, whether we win or lose in court. It depends on whether or not the system has integrity when we're done. That's my philosophy and my policy about what should and must be done in criminal courtrooms every single day.
Really, the issue, though, Warren, that I think the question should be asked: what will you do to ensure that the 1,000 prosecutors who are out there will do the same? And that involves instilling in them as a leader that that's what you expect. You expect all of them to behave that way, to turn over evidence. It's an embarrassment to this office when you see someone not following the ethical rules, not turning over evidence. And you could just notice the way my opponent answers the question. He doesn't understand that it's not going to be, he's not going to be a courtroom. The DA is going to be in charge of instilling ethics on 1,000, dare I say, strong-willed prosecutors. And so the issue is, and anyone around me knows this, I will be telling them on a regular basis, I expect nothing less than ethical conduct. I expect you to do it the way I say do it, which is if you have evidence that should be turned over, it must be turned over, it has to be turned over. And I think that is something that, quite frankly, is missing in some prosecutors' office. In our office, we actually, and it was at my suggestion, we now make it mandatory that everyone in that office undergo yearly Brady training so that they understand this is their obligation. And that's the difference.
The discussion you're about to hear began with a question concerning a case that hit the news in 2010, which accused sitting District Attorney Steve Cooley of essentially union busting. The Association of District Attorneys filed suit against the office, and Jackie Lacey was deposed as part of those proceedings. An issue that's followed her from that event is the fact that she changed an answer to one of the questions put to her during those proceedings. The fact that she blamed her erroneous comment on low blood sugar have left some amused and others with questions. Let's listen.